Well, welcome back, folks, to another episode of American Genesis, the creation of American Scripture. I apologize for not being with you last week, but the Michigan winters finally caught up with me. And we have lake effect snow going on today. As I was telling Rochelle, we've had a bunch of snow, so it's a good thing I like it, right? Well, let's get started with a little bit of music, as always.
If tomorrow all the things were lost I'd worked for all my life, and I had to start again with just my children and my wife, I'd thank my lucky stars to be living here today, 'cause the flag still stands for freedom and they can't take that away. And I'm proud to be an American, where at least I know I'm free. And I won't forget the men who died and gave that right to me. And I'd gladly stand up next to you and defend her still today. 'Cause there ain't no doubt I love this land. God bless the USA.
Okay, well, as you know, what we're doing is going through right now the Constitution in terms of looking at different sections of it, trying to figure out what's what. And we are starting the judicial branch today. And we'll be on that for at least this week and next week. Hopefully, I can get it done in 2 weeks. If not, we'll finish it and start with something else on the third week. Trivia question. When President George Washington became president, he appointed as the first Chief Justice of the Supreme Court who? What was the name of the first Chief Justice of the Supreme Court? Well, if you answered John Jay, you were correct. John Jay is a mostly forgotten man, although he was really one of the most important of the early founding fathers. Uh, Look at what he did. He was the president of the Second Continental Congress. He was a minister to Spain. He was the acting Secretary of State until George Washington appointed Thomas Jefferson. He was the Chief Justice of the Supreme Court, and he eventually became the second governor of the state of New York. On top of that, he, along with Alexander Hamilton and James Madison, authored the Federalist Papers, which just had a really important effect upon the ratification of the Constitution. By the way, the John Jay College of Criminal Justice, New York City, is named after him. Like I said, he was really a very important one of the members of the early founding fathers, but kind of a forgotten man today, which is kind of sad. Okay, well, let's get looking at the American legal system. And we're going to concentrate today on basically the principles of the American legal system. And then next week, we're going to actually get into the Supreme Court as such. The American legal system is pretty much unique, folks, in the world, because compared to most other democratic countries, no other country gives so much authority and political power to its judiciary. I mean, the America has really entrusted a tremendous amount of power in our judicial system. Traditionally, Americans have responded, the citizens have responded by placing a higher degree of trust in the judiciary than the citizens of other countries. And that's probably because we are built upon a certain bedrock principles, which all Americans really firmly, I think, for the most part, believe in. I think almost if you were asked every American, do they agree with this? I think most of them would say that they would. Number one, the concept of equal justice under the law. And we're going to talk about each one of these. Due process of law, the right to a lawyer, the presumption of innocence, and a trial by jury. These are the bedrock principles of the American judicial system. And these principles are so embedded in our judicial system that it's why most citizens, when asked of the three different branches of government, which one do they trust the most, is generally the judicial system. They have, I'll be honest, polls indicate they have almost no faith in the congressional system. They've had faith in the presidency kind of comes and goes depending upon who it is. I'll be honest with you. It's also true that in recent years, that trust in the American judicial system has somewhat begun to erode. And we'll talk about that towards the end of this when we talk about political power within the judicial system. Okay, let's look at this first of the bedrock principles: equal justice under the law. You know, that's something we hear all the time. It's engraved on the west pediment of the Supreme Court building. And although that phrase is not included in the original Constitution, it is included in the 14th Amendment, which states that no state shall deny to any person within its jurisdiction the equal protection of the laws. As we will find out, that has generally been, applied now to the federal laws as well. The phrase is generally seen as a political ideal that means all citizens are accountable to the same laws and is sometimes simply stated as no one is above the law. Now, you've probably heard that statement lately because there are people that, say, well, that's not necessarily true anymore, because it does sometimes appear that we have what's called a two-tiered system of justice that does seem to favor one group over the other. And that group depends upon who sometimes acts as being gored. Ox is being gored. I thought this was a pretty good commercial. Cartoon. The judicial system, you got the regular Joes here, me and you, lining up in the judicial system. And then you got the celebrity express lane. It does appear sometimes that people who of wealth and fame do sometimes seem to be treated different than those, like me and you. That shouldn't be the case, but it does appear that way sometimes. So that's number one bedrock principle. Number two, due process of law. That is a guarantee provided by the Fifth Amendment to the Constitution, which states that no person shall be deprived of life, liberty, or property without due process of law. And this whole concept originated in the English Magna Carta, which stated that no man shall be put out of his lands, nor taken, nor disinherited, nor put to death without due process of law. And what this simply means is that citizens are afforded the right to legal proceedings according to established rules and principles that have been established in the system of jurisprudence for the enforcement and protection of private rights. So that means, basically what it means is they have to follow the rules. There are rules set down. You know what they are. The government knows what they are. And they have to follow those rules in order for you to be, adjudicated in a court of law. Again, sometimes, some people wonder if we're really, kind of watering down the whole concept of due process. I thought this cartoon was pretty good. For the horrendous crime of being accused of sexual misconduct. In other words, you're being put to death just because you were being accused. Now, I don't want to make light of sexual misconduct and abuse because there's no, I'm not saying that at all. What I'm saying is that sometimes people felt like we maybe went just a little bit overboard here in the last few years when all it took was an accusation to derail a career, put you in prison, whatever. And supposedly you need to go through a certain due process, to make sure that you are adjudicated under the laws of this country. Thirdly, bedrock principle, right to an attorney, right to a lawyer. Now, this right was afforded in the Sixth Amendment, which protects the rights of individuals to have a fair trial before an impartial judge and jury. However, it's really important, and we'll talk about this a lot more later. This amendment did not originally apply to state courts. It only applied to federal law. And it was not actually applied to state courts until 1963, if you can believe that. Seems hard for us to concept that states didn't have to provide you with a lawyer, but up until 1963, that was the way it was. The Sixth Amendment also affords the right of the accused to a speedy and public trial. We'll be talking about that later. Informed of the nature of the accusation against them and to be confronted by witnesses. And again, this whole concept of a two-tiered legal system comes into play here because let's face it, folks, if you're a poor person, you sometimes get the lawyer that graduated at the bottom of the class. If you're a wealthy person, you can go out here and hire the best attorneys in the United States. And, I think we probably all remember the O.J. Simpson trial when he had this fantastic set of lawyers that just absolutely muddied the whole system to the point that he was found innocent. May have been innocent, may have not been innocent, but there's no doubt about it. Had he had Tom Jones off the corner lawyer's office, he probably would have been found guilty. Instead, he had this group of lawyers that were just fantastically talented and was able to basically, control the situation. So, yes, folks, if you can afford a good lawyer rather than one that's appointed to you by the government, you're probably better off. Let's just be honest about it, okay? Presumption of innocence. Another bedrock principle of the American judicial system is the presumption of innocence. This principle, like the others, is not found in the original Constitution, but again, it's embedded in the Fifth and the 14th Amendment due process clause. And the concept was further recognized as one of the most basic requirements of a fair trial by the Supreme Court in a case called Taylor versus Kentucky, which we aren't going to talk about. Supreme Court has ruled that prosecutors have the burden of proof to show the defendant is guilty beyond a reasonable doubt in a criminal law. So when you go to trial for a crime, a criminal infraction, the prosecution has to show that beyond a reasonable doubt, that you were guilty of that crime. Now, the burden of proof is a lot less in civil trials because there, all they have to prove is that it is more likely than not that you broke the law. So here's the difference, okay? In case you're wondering exactly how this plays out in real time. We just mentioned the O.J. Simpson case. O.J. Simpson was found innocent because there were some jurors that decided that they cannot be convinced that he was guilty of that crime beyond a reasonable doubt. That the attorneys for him was able to place enough doubt in their mind that they thought we cannot convict him because we don't believe that the state has proved their case beyond a reasonable doubt. But then O.J. Simpson turned around and was sued in civil court and found liable for a huge settlement because all they had to prove there was that it was more likely than not that he committed that crime. And the civil trial said, you've convinced us he's more likely than not committed that crime. So as a result, he was able, he was found guilty and had to pay a huge settlement. I'm not for sure how much of it he ever paid, but nevertheless, he was convicted in civil court and held liable for the death of Nicole. Okay, finally, the last principle, trial by jury. Trial by jury is the fifth bedrock principle, and it is clearly stated in Article 3 that the trial of all crimes, except in cases of impeachment, shall be by a jury. And the Sixth Amendment also adds into that, protects the right when it states in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. Now, we're going to talk about that in more detail. The Seventh Amendment also guarantees a trial by jury in civil cases seeking monetary damages. Now, there's some technicalities here. You might remember that Donald Trump was sued in a civil court of law in New York and was found guilty in a huge settlement against him. But it was settled by the judge, not a jury. He did not have a jury in that trial. I don't know exactly why, because New York law has some technical aspects to it that allows a judge to make a decision in civil trials without a jury trial. I don't know. To me, it doesn't make a lot of sense. But nevertheless, you have to have a jury trial if you want one in criminal cases. Here's a cartoon about the jury selection of the criminal court. Prospective juries, is there any reason you cannot be impartial? Yeah, the defendant looks guilty. I was once assaulted by someone with his hairstyle. I'm unemployed in my work just to pay for jury duty. I've slept with cops. My husband's second cousin is an LAPD. The defendant looks guilty. Another one's sleeping. I'm a determinist, so I don't believe in ultimate moral responsibility. My first language is Klingon, and on and on and on. Good cartoon there. Okay, so that is the 5 bedrock principles of our American legal system. Those bedrock principles that our judicial system is built upon, and it's the reason that we have so much faith, for the most part, compared to the other parts of our government in the legal system, is because, for the most part, those legal bedrock principles are followed through with. Now, we mentioned criminal and civil law. Let's kind of make sure we understand the difference. Okay, civil law attempts to settle disputes between citizens or organizations and does not necessarily involve criminal wrongdoing. So you can sue somebody for something without them committing a crime. That contrasts to criminal law, which is based on statutory law, and the state then becomes a part of the trial. The historical roots of our civil law lies in an old body of law called the Corpus Juris Civilis, the body of civil law in the Byzantine Empire, which is way back, 1,000 years ago, in the Middle East. That's where our civil law comes from. Criminal law involves offenses against the public where conduct is threatening, harmful, or endangering of property, health, safety, welfare of the people. And in criminal law, the legal jurisdiction where the crime occurs acts as the prosecutor against the defendant, whereas in civil law, private attorneys generally represent the two opposing parties. So let's break this down, okay? In civil law, the parties involved are private plaintiffs versus a private defendant, whereas in criminal law, the government is the one that prosecutes a private defendant. Standard of proof in civil is preponderance of the evidence, whereas in criminal law, it's beyond a reasonable doubt. The burden of proof rests with the plaintiff in civil law. So if you're suing somebody, you have to prove your case. The defendant doesn't have to prove anything. He can, but he doesn't have to. The criminal law yet the burden of proof lies with the government, the prosecutor. Examples of criminal law: breach of contract, personal injury. So if you sign a contract with someone and they break that contract, they haven't necessarily broken a criminal law. They may have, depending on the nature of the contract. But for the most part, they have not broken a criminal law. You have to sue them in civil court. Whereas in criminal law, they have to basically break an established law, burglary, DWI, murder, something like that. Penalties in civil law, financial compensation, restraining orders, injunctions, etc. Whereas in criminal law, the punishment, the penalties are a fine, incarceration, or restraining orders, injunctions, etc. So you can be put in prison for criminal law. Okay, so what does our Constitution say about courts? Well, actually, it says very little. Okay, that was by compromise because Article 3, Section 1 states the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may establish. That's really just about all it says about the establishment of courts in the Constitution. And like I said, that was a compromise because the Federalists desired a supreme national court, but the anti Federalists, those opposed basically to the whole Constitution, wanted all judicial decisions to be made at the state level. And they finally came up with this compromise to have one Supreme Court and let Congress make all the other courts. The fact of it is, though, most legal cases are not heard in federal court. Most legal cases are heard in local and state courts rather than federal judicial courts. So, it's federal law only applies in certain cases. Usually, most cases are heard in state and court, local municipal courts. Now, since that time, Congress has established a hierarchy of federal courts. So it says here, Congress may establish. So Congress has established a certain hierarchy. To begin with, they have the United States Supreme Court. Originally, they had the U.S. District Courts. But somewhere along the line, in the late 1800s, they decided there was so many cases getting to the Supreme Court that there needed to be a buffer between the district courts and the Supreme Court. So they created what was called the U.S. Courts of Appeals. And today there are 12 of those. In addition, there's all sorts of specialized courts, which we'll kind of talk about here just real briefly in a minute. Okay, so let's look at these federal district courts. These were the first courts established by Congress. Today, there are 94 of these with 677 judges. Each state has at least one judicial district. Now, 2 judges are generally assigned to each district. There may be more. It depends on the judicial district and how big it is and how important it is. These courts have original jurisdiction almost all federal cases here in both criminal and civil law. Most cases, not all. Federal district courts utilize both grand juries and petit juries. A grand jury is a jury that meets in secret with the prosecutor and brings charges against someone. A petit jury is the jury of your peers that hears cases and makes decisions. The federal district judges are paid $223,600 per year and hold their position for life. It's a good salary. I would love to make $233,000 a year, but I don't make anywhere near that. Okay, I never did make anywhere near that. But in the scope of things, it's not just a terrifically high-paid position. A very successful private lawyer can make a whole lot more money than that. Let's put it that way. Okay, these are the different federal district courts. In the United States. You can see, like in Missouri, they have 2, in Illinois, 7, in Colorado, they have several different ones. So these are the federal district courts. Now, as I said, in the late 1800s, there were so many cases reaching the Supreme Court that were being appealed from the district courts that the Supreme Court was beginning to be overwhelmed and could not hear all the cases. So they decided to create what was called the Circuit Courts of Appeal. Pardon me, I'm sorry. Need to get a drink here. And these circuit courts of appeal were created to be kind of gatekeepers for the Supreme Court. It was set up to kind of make sure that cases, could be heard prior to getting to the Supreme Court. And the purpose was to relieve the Supreme Court of hearing most appeals from federal district courts because the numbers had grown so drastically. Today, there are 11 federal circuit courts of appeals with 179 appellate judges. And again, most of them have 3 judges, and they hear appeal cases from the region from which they served. And they also make $236,900 a year. Again, not a huge salary. However, I have to tell you that most Supreme Court justices eventually come out of the federal district courts of appeals. Most Supreme Court justices are reached that level from this level. And again, you can see the assignments here. This is one of the courts of appeal. This is another one. This is another one. The orange is another one. The purple, the yellow, the blue, the green, the bronze or brown or whatever you want to call it. And this kind of light shade of blue-green and then the dark blue here. So these are the different courts of appeals that exist in the United States. So if you're in the district court in South Dakota and you appeal your conviction from a federal district court to a court of appeal, it's going to be heard somewhere. I believe actually the federal district courts of appeal may be in Missouri. I think it may be in Kansas City or St. Louis. I'm not for sure. So it's it's heard in one of these jurisdictions here. So in addition, there are specialized courts. These are courts that the jurisdiction is limited in real scope. Now remember, all these courts, except for the Supreme Court, were created by Congress because the Constitution speaks very little about the court system except for the Supreme Court. There are military courts, which hear appeals on serious court-martial convictions. So they hear appeals within the military system. There's federal tax courts, which hears only civil cases involving disputes over the application of tax laws. Very complicated. Territorial courts, Puerto Rico, Guam, the Virgin Islands, different territories of the United States have their own court system, which operate much like a state court, but they are run by the federal system. The courts of international trade, which hears only civil cases arising out of tariff and other trade-related laws. Again, very complicated situation. Federal Claims Court. If you want to sue the U.S. government, there's 2 things that have to happen. Number one, they have to give you permission to sue them. You cannot sue the United States unless they give you permission to sue them. And if you do sue them, you go to a federal court, a claims court, which you will sue the government in federal claims court. And then there is a federal bankruptcy court, which differs from the state and local bankruptcy courts because they hear federal bankruptcy cases. And again, they have certain limited jurisdictions. And finally, there are federal courts of veteran appeals, which hears appeals from veterans who feel like they've been not treated fairly. And you can appeal a decision from the Board of Veterans to a federal court of veterans appeals. Again, most of these are very specialized courts, which most people will never have anything to do with. Okay. Now, how do you get to be a federal judge? Well, Article 3, Section 1 states that all federal judges are appointed for life and can only be removed through impeachment. So it's a lifetime job. Once you get it, you got it for as long as you want it or until you were impeached. All federal judges are appointed by the president, but must be approved by the Senate. So right now, President Biden is just absolutely going crazy appointing judges. And that's not unusual, folks. Every president does this. This is if you listen to the news, you would think that he's the first president that ever did this. He's not the first president that ever did it, and he won't be the last president that ever did it. They all do this, particularly if the presidency is changing parties, which it is. Now, it just so happens that the Senate is also controlled by the president's party, and that will change also here in about a week. So the president and the Senate are doing everything they can to approve just as many judges as they can, because those judges will be there for life. And once they're there, they can have a profound effect upon decisions of Congress and the presidency. The appointment of federal district judges is really pretty routine. So to be appointed to a federal district judge is I won't say it's not political, but for the most part, it's a little bit less political than some of the other the Court of Appeals and definitely Supreme Court. There's something called senatorial courtesy, and it's not always followed, but for the most part, if you are a federal district court and you're being appointed, you've been nominated to be in a federal district court, let's say in Iowa, as long as the two senators from that state approve of that nomination, it's kind of automatic. Not necessarily, but for the most part, it's pretty much automatic. It's something called senatorial courtesy. So let's say that the two senators from Iowa, they look at this Supreme Court or this federal district court, that judge that Biden is nominating, and they look at him and they say, well, he's okay. I may not agree with everything they do, but I think they'll be as fair as they can be. And so they basically say, okay, it's okay. We don't have a problem with that. Now, if they have a problem with it, they can do something what's called a blue slip. You don't hear about this much, but they basically can go to the other senators and say, hey, I'm not going to approve this senator. This judge, he's going to be in my state. I don't like him or he or her. I don't think they're doing a good job in the judgeship they're already in. Most of them are already in a judgeship. I think it's not just because of their politics. I just don't think they're going to be a good judge. So I'm going to blue slip this nominee. Now, that doesn't necessarily mean they won't be appointed, but it really makes it much more difficult if the senator disagrees that in the state that the judge is being appointed. So, when Senator Biden appoints a federal district judge or a federal district court of appeal or a Supreme Court, basically he has to have the approval of the Senate. Now, it gets a lot harder when you're going to be appointed to the Supreme Court. Okay, the Supreme Court is obviously a very important position in this country today. In fact, there will be people argue that there may not be any more important position in America besides the president, other than the Supreme Court justice. They have tremendous powers in our country. And for the most part, it's historically it wasn't too bad. Recently, it's become much more partisan and much more political. This all started in 1987. And again, I'm not taking political sides here. I'm just telling you the facts as they are. Two Democratic Party senators, Ted Kennedy principally, and Joe Biden, rejected a Supreme Court nominee by Ronald Reagan by the name of Robert Bork, who they felt like his past, they really portrayed it in such a way that he was a racial bigot, that he was unfair, and as a result, he was rejected by the Senate. It was really a change, folks. Up to that point, most presidents, if they appointed someone to the Supreme Court, there might be an occasion where one would be rejected. But for the most part, the Senate said, well, we may not like this appointment, but our time will come. From this point on, you know, things change. In fact, there is a term you can be borked. That's what they call it now, where basically your past is brought up and dredged up to the point that it is oftentimes distorted. We've seen this in recent times on both sides. The president usually appoints a nominee to the Supreme Court who shares his judicial and political ideology. Now, they're going to tell you, I don't have a litmus test. Well, most of them tell you that. I will give credit to President Obama. He just flat out said, yeah, I've got a litmus test. I'm only going to appoint people to the Supreme Court that agree with my political ideology. I mean, you may agree or disagree with President Obama, but at least he told them the truth. He said, I'm not going to play this game of saying I don't have a litmus test. Every president has a litmus test. Every president tries to appoint people that agree with his political philosophy. There's no doubt that President Biden has done that. There's no doubt that President Trump did that before him. And there's no doubt that if a Supreme Court nominee is put before the Senate in the upcoming term, that President Trump will again appoint someone who agrees with him, in certain areas like abortion, gun control, etc. Now, it's also true that they try to reach certain balances, ethnic, racial, and geographic, at least in modern times. Here's the problem. Sometimes presidents appoint people thinking they're going to do one thing, and they end up being something else. Classic example. In 1953, President Eisenhower, who was basically a conservative person, appointed the governor of California, Earl Warren, as the Chief Justice of the Supreme Court. Kind of a surprise. Normally, Chief Justices come out of the court system. Earl Warren was the governor. And so, he was approved without a doubt. Just rushed through. And I'm sure that Eisenhower, I've read biographies, I know that Eisenhower and some of his advisors thought that Earl Warren was going to be a conservative, he was going to basically follow traditional ideas. Nothing could be further from the truth. Earl Warren ended up leading the most progressive court that we've seen in modern times. So sometimes politicians don't do a very good job of appointing people to the Supreme Court that they think are going to do what they do. And you can find that in every case. I can think of a case right now. I know probably one of the Supreme Court justices that faced the hardest time getting to be approved in recent time was Justice Kavanaugh. And I don't want to rehash all that, but I think you all remember what he went through a few years back when Trump appointed him. And everybody thought that he was going to be, at least the liberal factions in this country thought he was going to be absolutely the worst Supreme Court justice in history. You would have thought he was the devil incarnate. As it turns out, if you look at the record, he is actually voted quite often with what's called the liberal faction of the court. He's not quite what I think probably some of those people thought he was going to be on both sides. I don't think probably the conservatives are quite happy with some of the things that he votes for. I'm sure the liberals are quite shocked at some of the things that he's voted for. So you never really know, folks, how this is going to turn out. By the way, that is Robert Bork. That is the Supreme Court nominee that kind of changed this whole thing around. Now, last thing, historic makeup of the Supreme Court. There's been 116 individuals that have served on the Supreme Court since 1789. All of them, except 4, have been white, and all but 6 have been male. So it is traditionally a white male situation. That has obviously changed in the last, several decades. There are the four minority justices that have been appointed. Was the first one was Thurgood Marshall by LBJ in 1967. That was Thurgood Marshall. Uh, Clarence Thomas was appointed by George H.W. Bush in 1991. Sonia Sotomayor was appointed by Obama in 2009, and Ketanji Jackson Brown by Biden in 2022. Those three, Thomas, Sotomayor, and Brown, are still serving in the Supreme Court. There have also been only 6 women justices. The first one was appointed by Ronald Reagan, which shocked a lot of people. A lot of people were surprised that he would appoint a woman. Again, that just goes to show sometimes we don't really know what these people are going to do. Ruth Bader Ginsburg was appointed by Clinton. Sotomayor was appointed by Obama. Elena Kagan was appointed by Obama. Amy Coney Barrett was appointed by Trump, and Ketanji Jackson Brown was appointed by Biden. 4 of those, the last 4, 3 through 6, are still on the Supreme Court. So, for the most part, since this whole thing has started changing and you see more women and minorities, this has only happened within most of our lifetimes. You got to be pretty young not to remember when remember it was all white males court. Most appointees have law degrees from prestigious universities. So, folks, if you want to be a Supreme Court justice, for the most part, you either go to Harvard or Stanford or Yale. There are exceptions, and there's exceptions on our current Supreme Court, as I'll show you in a second. Most of them have held political office as well as lower courts, been a judge in lower courts. So a lot of times these are political people. They're not paid an astronomical amount. The Supreme Court associate judges are paid $274,200. The Chief Justice is paid a little bit more, $286,700. But again, folks, this is minuscule in compared to what a good lawyer that in a big city can make. I mean, these people, some of these big lawyers can make that much in one case, easy. Okay. So who is on the Supreme Court right now? This is where we're going to finish today. Well, you have 9 people. You have Amy Coney Barrett from Notre Dame. She's one of the exceptions. She's not a Yale, Harvard, Stanford person. Okay. She was appointed by Trump in his first administration. You have Neil Gorsuch, who graduated from Harvard Law, also appointed by Trump, and Brett Kavanaugh from Yale Law School, appointed by Trump. These 3 were appointed by Trump. You have Ketanji Jackson Brown from Harvard, who was appointed by Biden. She replaced Ruth Bader Ginsburg. You have Sonia Sotomayor, who was from Yale, appointed by Obama. You have Clarence Thomas, who is the oldest person on the Supreme Court. And a lot of people are thinking he may retire this next session since Trump has now been elected president and can replace him with another conservative. Clarence Thomas has been there since 1991, so quite a few years. John Roberts was appointed by Bush II from Harvard. Samuel Alito was also appointed by Bush II, I believe. And Elena Kagan was appointed by Obama. So, and all these were from Harvard or Yale, except for Amy Coney Barrett, who was from Notre Dame School of Law. So that's it for today. So where are we going to go next week? Well, we're going to hopefully finish up the judicial system. We're going to look at what happens when a case reaches the Supreme Court, because it's different than any other situation. I can guarantee you, the Supreme Court doesn't act like any other court of law. So that's what we'll do next week. And the week after that, if we finish up next week, we will look at the remainder sections of the Constitution. Then we're going to start on what I hope your part, I think, will maybe bring a little bit of interest back. I know some of this is kind of boring, some moments, and I apologize for that. Anyway, we'll try to get into the Bill of Rights, which I think you will really enjoy because it talks about things that we can really understand. That's oftentimes applies to us. When can we pray? When can our students pray in school? Can you burn the flag? Can somebody be forced to say the Pledge of Allegiance, etc.? Those kind of things like that. So, anyway, we will see you next Monday, which happens to be MLK Day, which happens to be Inauguration Day. Oh boy, So we will be looking at this hopefully next Monday and go from there. So I will let you go and we will see you next week.